I think we all know who that is, at least anybody that's been here before. So, Senator Grendell.
Thank you very much. First of all, thank you for being here and staying committed to fight for what's right, and that's for the property rights of folks along Lake Erie. And thank you for letting me join you again this evening. I don't want to say we've been at this for a long time, but I think I actually still had hair when we first met. I might have been combing it from one side to the other, but I had hair when we first met. I can't tell you how great it is to have SOS come here and share with us what happened in Michigan. And can't tell you how glad I'm still live in Michigan, by the way. I felt that way about football. Now I feel that way about property rights. But and I can't tell you how lucky you are to have Maurice Thompson and the 1851 Center on board on this issue. Let me tell you a couple things about Maurice. He is my favorite lawyer in the state of Ohio. Now, why do I say that? Now, I say that because just this year, Maurice and the 1851 Center are the guys who chased acorn out of the state of Ohio. If you're not happy with the cram down of the health care bill from the federal government, there is an effort to get a constitutional amendment on the ballot in Ohio this year to allow us to use the 10th Amendment to try to elect out of the forced health care provisions of the Obamacare provision. And the Secretary of State tried to break that up so we could get it on the ballot in one measure. And 2 weeks ago, Maurice Thompson won the lawsuit in the Ohio Supreme Court against the Secretary of State. So when Maurice Thompson says he's showing up to help us protect these property rights and is going to do an amicus brief, that's good news, folks. That's very good news. Now, there's a couple other things I like about Maurice. Maurice reminds me of me 30 years ago, except with hair and thinner. But he went to graduated Case Western Reserve University Law School, so he's a fellow alumni, and he gets it. I mean, he's a very bright young man. He's dedicated. His organization is a nonprofit organization that also lives, by the way, on the gratuitous help of other people who contribute to keep them alive. They have some big donors, but by the way, if you decide you want to help another organization, in addition to my plea I'm going to give you about the Lakefront Group, remember the 1851 Constitutional Center. It's very important for us, not just on this issue, but believe me, in the future, we got many issues to fight. I might add, for you who might care about history, 1851 is not an accident. That was the year of the good Ohio Constitution. We had one in 1803, we had the really conservative one in 1851, and then we had the progressive one in 1912, and everything since then has been sort of bits and pieces from that. So he picked the right year in 1851 with the Center, but we look forward to having him on board. So you know, we've been looking for amicus. Tony, Vidas, Greg, we've been looking for amicuses. What's an amicus? An amicus, you saw that comment about the policy. Supreme Court judges tend to think they get to do policy. That's supposed to be the legislature, but we'll just set that aside for this evening. But the amicuses are the people who try to educate the judges on the impact that a case of this nature will have on the state from various perspectives. The environmentalists will have amicuses. They'll have several of them, I'm sure, trying to talk about how somehow from the beginning of mankind we all had the right to walk on everybody's private property when it's located along the lake. It's great to have Maurice make that explanation of the fundamental aspect of property rights. We're talking to the Farm Bureau. We're talking to other organizations that are involved in the real property world. I'm going to write an amicus brief along with a couple other senators. We're going to try to make sure the Supreme Court understands how important it is that they stand up for property rights on this issue. So that is a major thing, and the good news is, you know, the amicuses don't come out of your wallet. Okay, you're still paying for your lawyer, and you need to still do that, as I'll get to in a minute. But here's how I see this thing. This thing is like a horse race. You know, when Odie and I first showed up and pulled the same tricks that they're up to now on the Vermilion River, but on their lakefront, you know, we came out of the gate. And we came out of the gate strong. You all came down to Columbus, you filled up buses, we had some good legislative push. We were actually successful in getting a bill out of the House, and we were moving. And then Odie and I hired a senator out of the Senate, and he threw up some obstacles, and we sort of lost ground, and we couldn't get it out of the Senate. Then Odie and I snuck in that language to kind of close the window on the statute of limitations for you bringing this lawsuit. And we caught that with literally weeks to spare. but you folks got into high gear. You got legal counsel. You got the suit filed, the Merrill suit, the Taft suit, got them filed so that we were back in the race. Then ODNR, with the help of the Attorney General, shows up and throws another obstacle. They sent you out to the federal courts with this goofy federal claim. And we spent a year in the federal courts, lost a little ground, but you prevailed, and you picked up speed, and you got over to the back into the state court. Then Judge Lucci, and I got to tell you, Judge Lucci wrote one heck of a great decision. He recognized your property rights. He recognized the insanity of what was going on. And we picked up some more speed on the back stretch with Judge Lucci. Then we got to the 11th District Court of Appeals, coming around the turn. You may not know this, but a week before oral argument, the Attorney General and the environmentalists filed a motion to have my wife thrown off the case. She was one of the 3 judges at random selected for the 11th District case. If you read their motion, it was a 16-page attack on me. I was the worst thing that ever existed in the state of Ohio. I was road sludge. I was a menace to the public's right to step on people's property. But they never mentioned my wife in the entire motion except that she was married to me. And Justice Moyer, who denied their motion to let my wife sit on the case, made a very interesting observation. She said, being married to Tim Grendell is a cross that Judge Grendell's going to have to bear. But that's her choice. Senator Grendell is not the judge hearing this case, and they couldn't point to one place where my wife had ever said anything publicly about this issue. And nor did she ever advocate for the legislation, because we keep the separation of, judicial and legislative in our household. Judicial wins all the time, that's another issue. The guys in this room will appreciate that. But the decision came out. And the decision was interesting. All 3 judges, the 2 Republican, the 1 Democrat, all said your property rights go to the water's edge. There was no disagreement on that. 2 of the judges, my wife and Judge O'Toole, said, however, the Attorney General has no client. Because back when Ted Strickland and ODNR switched sides in this case, and actually got their own lawyer to represent them, the Attorney General had nobody to represent anymore. And in fact, in the oral argument, in the 11th District Court of Appeals, the first question asked the Attorney General lawyer arguing was, who do you represent? And her answer was, the public trust. And the question was, who's that? I mean, who is the public trust? And to give you one annoyance about the Attorney General's position here, for those of you who don't like the health care bill, and I'm going to be honest, I'm one of those, 12 Attorney Generals have challenged the health care bill in federal court. Rich Cordray, our Attorney General, won't do that. There's at least a couple million Ohioans who aren't happy with Obamacare who would like to have that challenged in federal court. He won't do that. Yet he will represent, who knows, the unknown against you in this action still in the Supreme Court. I still find that to be outrageous from that perspective. But now we're making